Definition and primary concept. Article 219K defines unfair labor practice as unfair labor practice means any unfair labor practice as expressly defined by this code. Nature of unfair labor practice. Article 258, Labor Code. A. Inimical to the legitimate interests of both labor and management, including their right to bargain collectively and otherwise deal with each other in an atmosphere of freedom and mutual respect. B. Disrupt industrial peace. C. Hinder the promotion of healthy and stable labor management relations. D. Violations of the civil rights of both labor and management but are also criminal offense. What is unfair labor practice? Unfair labor practice refers to acts that violate the worker's right to organize. The prohibited acts are related to the worker's rights to self-organization and to the observation of a CBA. Without that element, the acts, no matter how unfair, are not unfair labor practices. The only exception is Art. 259 FIE, to dismiss, discharge or otherwise prejudice or to dismiss, discharge, or otherwise prejudice or discriminate against an employee for having given or being about to give testimony under this code. Facts. The company entered into a contract with Marine Security Agency to guard their vessels in the port. Contract was for 1 year and may only be terminated by either party upon 30 days' notice. The arrangement was that Marine Security Agency would hire and assign the guards, a lump sum given to agency who in turn determined the compensation of the individual watchman. Contract was terminated on January 4, 1961. After it expired, the company entered into a new contract. W. Scout Veterans Security and Investigation Agency in the same terms and also for 1 year. Union abolished themselves due to termination of contract, inability of agency to provide employment, and inability of members and union to provide maintenance. Respondents claim that the termination of the contract, despite 10 years of service, was because of a misunderstanding between Captain Morris, rep of company, and Mr. A. Tinsey, operator of said watchman's agency, wherein Tinsey allegedly threatened to cause the company trouble. Capt. Morris. Union soon passed resolution reviving itself. The Maritime Security Union, through individual complainants, headed by Julian Advincula, filed unfair labor practice against petitioner company on March 21, 1963. Their complaint charged that the petitioner had refused to negotiate an agreement with them and had discriminated against them with regard to their tenure of employment by refusing to negotiate a CBA with them and dismissing them on January 1, 1961, for no other reason than their membership with the union and union activities. The complaint was transferred from CIR to NERC. Law agreed they were employees and there was he ordered reinstatement and 3 years of back wages. NERC agreed but qualified only those complainants who are 60Y or O or younger, and can discharge the former duties should be reinstated. W or O loss of seniority rights, and if not reinstated, give separation pay plus back wages. Minister of Labor and OP affirmed issues. W or N there existed an employer-employee relationship between the petitioner and the individual watchmen of the Marine Security Agency who are alleged to be members of the respondent union. W or N the company refused to negotiate a CBA with the said individual watchmen and discriminated against them in respect to their tenure of employment by terminating their contract on January 1, 1961, because of their union activities. Held, no complaint for unfair labor practice. Dismissed. 1. As to E or relationship, to determine the existence of or E relationship. 1. Selection and engagement of the E. 2. Payment of wages. 3. Power of dismissal. 4. Power to control the E's conduct. Most important element. The complaining watchmen of the Marine Security Agency cannot be considered as employees of the petitioner. It is the agency that recruits, hires, and assigns the work of its watchmen. Hence, a watchman cannot perform any security service for the petitioner's vessels unless the agency first accepts him as its watchman. With respect to his wages, The amount to be paid to a security guard is beyond the power of the petitioner to determine. The lump sum paid to the agency for its services is more than the wages of any one watchman. Also, no power to dismiss company can ask to change guard, but agency still has final say. The agency always stands between her and ye, and contract has clearly ended. 2. As to unfair labor practice, as there is no year relationship, cannot be guilty of unfair labor practice under RA 875, Sec. 13a. Unfair labor practice may committed only within the context of the year relationship, but to court resolve the merits of the case. The court finds it hard to believe that there was a desire to negotiate a CBA, since apart from their oral declaration, respondents have not presented any written proof which is required by RA 875. At the time, the union was represented by counsel, and if such requests were made, the counsel failed to advise his clients on the law. No proof termination of contract due to alleged union activities. The contract validly expired. Letter of counsel said the basis of the termination was misunderstanding between Capt. Morris and the agency. The most telling evidence of the shallowness of private respondents' charge of unfair labor practice is the respondent union's own resolution to abolish itself. If respondent union felt aggrieved by the unfair labor practice it had imputed to the petitioner, why did it abolish itself instead of putting an end to its own existence? Why did it not prosecute its charge with dispatch? Considering that an unfair labor practice by an employer is an affront against the very integrity and existence of a union? What is worse is that in its resolution of abolition, the respondent union confessed that it is the Marine Security Agency that provided employment to its members. There can be no clearer proof that such an admission that it is indeed the agency, not the petitioner, that is the employer of its watchmen. Employer-employee relationship required. General rule: an unfair labor practice may be committed only within the context of an employer-employee relationship. Exception: yellow dog condition or contract, to require as a condition of employment that a person or an employee shall not join a labor organization or shall withdraw from one to which he belongs. Art. 259b. Requisites of a yellow dog contract. 1. A representation by the employee that he is not a member of a labor organization. 2. A promise by the employee that he will not join a union. 3. A promise by the employee that upon joining a labor organization, he will quit his employment. As a SENA Act must specifically defined in the law. Art. 259. Unfair labor practices of employers. It shall be unlawful for an employer to commit any of the following unfair labor practices: to interfere with, restrain or coerce employees in the exercise of their right to self-organization, to require as a condition of employment that a person or an employee shall not join a labor organization or shall withdraw from one to which he belongs, to contract out services or functions being performed by union members when such will interfere with, restrain or coerce employees in the exercise of their right to self-organization, to initiate, dominate, assist or otherwise interfere with the formation or administration of any labor organization, including the giving of financial or other support to it or its organizers or supporters, to discriminate in regard to wages, hours of work and other terms and conditions of employment in order to encourage or discourage membership in any labor organization. Nothing in this code or in any other law shall stop the parties from requiring membership in a recognized collective bargaining agent as a condition for employment, except those employees who are already members of another union at the time of the signing of the collective bargaining agreement. Employees of an appropriate bargaining unit who are not members of the recognized collective bargaining agent may be assessed a reasonable fee equivalent to the dues and other fees paid by members of the recognized collective bargaining agent, if such non-union members accept the benefits under the collective bargaining agreement, provided that the individual authorization required under Article 242, paragraph O of this code shall not apply to the non-members of the recognized collective bargaining agent to dismiss, discharge or otherwise prejudice or discriminate against an employee for having given or being about to give testimony under this code, to violate the duty to bargain collectively as prescribed by this code, to pay negotiation or attorney's fees to the union or its officers or agents as part of the settlement of any issue in collective bargaining or any other dispute, or to violate a collective bargaining agreement. The provisions of the preceding paragraph, notwithstanding, only the officers and agents of corporations, associations or partnerships who have actually participated in, authorized, or ratified unfair labor practices shall be held criminally liable. Art. 260. Unfair labor practices of labor organizations. It shall be unfair labor practice for a labor organization, its officers, agents or representatives, to restrain or coerce employees in the exercise of their right to self-organization. However, a labor organization shall have the right to prescribe its own rules with respect to the acquisition or retention of membership, to cause or attempt to cause an employer to discriminate against an employee, including discrimination against an employee with respect to whom membership in such organization has been denied, or to terminate an employee on any ground other than the usual terms and conditions under which membership or continuation of membership is made available to other members, to violate the duty or refuse to bargain collectively with the employer, provided it is he representative of the employees, to cause or attempt to cause an employer to pay or deliver or agree to pay or deliver any money or other things of value in the nature of an exaction for services which are not performed or not to be performed, including the demand for fee for union negotiations, to ask for or accept negotiation or attorneys' fees from employers as part of the settlement of any issue in collective bargaining or any other dispute, or to violate a collective bargaining agreement. The provisions of the preceding paragraph, notwithstanding, only the officers, members of governing boards, representatives or agents or members of labor associations or organizations who have actually participated in, authorized, or ratified unfair labor practices shall be held criminally liable.